All right, let's talk about logical and legal relevance. From a rule perspective, we're talking about Federal Rule of Evidence 401, 402, and 403. Now, the problem with logical and legal relevance is that you've got to step back and think about systemically, from a policy perspective, what it is that the Federal Rules of Evidence are doing. And the purpose of the Federal Rules of Evidence from a relevancy standpoint is that relevancy serves as the initial screen that we use to determine whether or not evidence should be heard by the court. I mean, let's go and look at Federal Rule of Evidence 401. Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Well, what the heck does that mean? It means that if the jury were to hear the answer to the question that is posed or to see the piece of evidence that is proffered, they might take that evidence might move their consideration of what did or did not happen, however slightly, in one way or the other. So if you'll think of, we'll use the slide of not guilty to guilty, and we'll even presuppose that the jury starts right in the middle. Counsel asks questions. They admit evidence. Every answer to a question is a potential piece of evidence. Every document is a potential piece of evidence. Those pieces of evidence come in and they ping against the needle of the jury, and it moves so slightly towards closer and closer and closer to guilty. And then the defense counsel at the same time is asking questions, trying to move the arrow the other way. Any piece of evidence that moves that arrow, however slightly, on that continuum, on any element of a charged offense or any element of a raised defense, is potentially relevant. Well, what does this mean? It means that the relevancy requirement from a logical perspective is phenomenally broad. Almost anything can arguably be logically relevant. It also means that logical relevance by itself doesn't do very much to help us determine what is or is not admissible. Think of 401 as a general statement of the rules of evidence from an aspirational standpoint. What we're saying is if the evidence helps the jury understand the issue, we're going to admit it because it's logically relevant, subject to the limitations of the other rules. Let's look at 402. All relevant evidence is admissible except as otherwise provided by the Constitution of the United States, by act of Congress, by these rules, or by other rules prescribed by the Supreme Court pursuant to statutory authority. Evidence which is not relevant is not admissible. That's a restatement of the thought process that the rules of evidence from a code perspective are inclusive. We begin with the idea, unless it is specifically excluded, if it is relevant, it is admissible. And that's what 402 does for us. So I read 401 and 402 together. And that sets me up for my understanding of the most important relevancy rule. And I refer to this rule in my writings and in my thought process as legal relevancy. And what do I mean by that? I mean that evidence which is logically relevant can, for purpose of a legal rule, be excluded and not given to the jury. And if we carefully read the text of Federal Rule of Evidence 403, we begin to understand how this balancing test works. Now, I want you to look at your rule. Take a look at it. Although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Now, if I read this rule properly, I focus in on substantially outweighed by. And I think of it as a scale. On one side of the scale, I have probative value. If I have logical relevancy, there's some probative value to every piece of evidence, right? No matter how slight. It's got some probative value. And logically, under 401 and 402, that gets me through the door into considering its admissibility. But there are some times where, yeah, it's logically relevant, but it's really not extremely helpful. And there's some problems if we just let in everything. So I look at the substantially danger that it will be substantially outweighed by. The danger that it will be substantially outweighed by. This is like the fulcrum on my scale. This is the test that I use. Probative value, danger that it will be substantially outweighed by. In other words, the probative value will be less than this other thing that's going to potentially happen. And the other thing that's going to potentially happen is what? The substantial danger of unfair prejudice, the confusion of the issues, the waste of time, and considerations of delay. That means that I could have a piece of evidence that's got some probative value, but it could also unfairly prejudice the case against the party of which it's offered. And I weigh the substantial danger of unfair prejudice against the probative value that it has. And if the substantial danger of unfair prejudice substantially outweighs the probative value, I don't admit it. That is a word game. That is an ability to properly marshal the arguments to show what is or is not admissible. For example, I could have a witness who's on the witness stand who's testifying in a case, and that witness could have been convicted of several crimes that were all misdemeanors, and they're all 15 or 20 years of age, how old they are. So they probably won't be admissible under Federal Rule of Evidence 609 for impeachment. But they want to ask this witness about them to see if they'll lie. What value, really, does inquiring with this witness about convictions that are that old have to do with what it is they're testifying about today? Unless I can connect the potential value of those other events to the proffered testimony, the probative value of the proffered testimony, I'm going to exclude those questions because there's no probative value in asking them, and there's a substantial danger of unfairly prejudicing the jury against the witness. That's the way in which this rule works. And the interesting thing about Federal Rule of Evidence 403 is it's the catch-all rule. It's the rule that you always go to unless the evidentiary code specifically identifies an alternative rule. That happens. In Federal Rule of Evidence 609, when I'm dealing with convictions for crime and falsity crimes, in the first 10 years after the conclusion of the sentence, I don't get to apply the 403 balancing test because the rule specifically delineates that I don't get to do that. When I'm dealing with the convictions of the accused that are offered, as opposed to the convictions of any other witness, I reverse the 403 balancing test under 609, and I give additional protections from a relevancy perspective to the accused. So what does that mean? It means that where I don't see a rule that specifically changes the balancing test for legal relevancy, Federal Rule of Evidence 403 applies. And that's why trial lawyers always fall back on Federal Rule of Evidence 403 as their last objection when they're dealing with these sorts of issues at court. Objection, Your Honor. There's a substantial danger of unfair prejudice. There's no probative value. How, counsel? And then the argument begins. Let's take a look now at the character rules of evidence, Federal Rule of Evidence 404A, Federal Rule of Evidence 404B, and see if we can bring some understanding to how character works in a federal courtroom.